from St. Louis Public Radio. This is St. Louis on the Air.
Do you think this ruling is enough to put police departments on notice that they need to be more careful with this kind of restraint?
I think it should. I think it should put both courts reviewing these cases on notice that they need to be particularly careful with this type of restraint. And it should put police officers on notice as well that they need to follow the well-known guidance. Now, I think we need to go further. I think that it would be great to see an opinion from the Eighth Circuit that addresses some of these issues. I think we need more, but I think this is a great first step.
I'm Sarah Fenske. Last week, the U.S. Supreme Court gave new life to a lawsuit in a way that no one saw coming, not even the lawyers who'd petitioned the court for help. The lawsuit involved a man who died in St. Louis police custody, and the court's reversal of two lower courts gives new hope to the family members he left behind. And joining us today with the latest is Kevin Carnie Jr. He's an attorney with the Simon Law Firm here in St. Louis. Kevin, welcome.
Thank you for having me. Great to be here.
So, Kevin, this case was unusual in that the Supreme Court did not ask either side to make arguments before it. How did you find out that they had taken on this case?
Yeah, so I found out from a colleague. You get an email when you figure out that the court's going to take action in the case, and the opinion was right there, and I jumped in and started reading it, so it was great news to receive.
So your first inclination that they were going to consider this was this ruling they'd already made?
Yes.
And that's very unusual in your profession.
It is. Now, first of all, anytime you ask the Supreme Court to review a case, it's rare for them to accept it. But then on top of it, the way that this opinion was issued was also rare. This was a win for a plaintiff in a civil rights case, and that's rare before the Supreme Court. But also, in the way that the Supreme Court issued the ruling, it was a summary reversal, meaning, as you mentioned earlier, they didn't ask us to come in and make oral arguments. They took a look at the briefs and decided to issue an opinion reversing what the Eighth Circuit did.
Yeah, so this is a big deal. And as you mentioned, this is a civil rights case. I want to just talk a little bit about your client. You represent the family of Nicholas Gilbert. Who was Nicholas?
You know, Nick was a 27-year-old young man. He had a loving family. He was, according to his parents, a bubbly guy, a happy guy. He had plans in life, and I can tell you his family misses him dearly.
And so his family ended up filing this lawsuit against the St. Louis police after his death. What were the main allegations in this suit?
So Nicholas was picked up by the police on charges of trespassing in a condemned building, and he also had an outstanding traffic ticket, a warrant for a traffic ticket outstanding. So he was taken to the holding cell in St. Louis, where it was around 2 p.m. he was taken into the holding cell. Around 6 p.m., some of the officers said that they saw him potentially with his sweatshirt tied up around one of the bars. And so they said they entered the holding cell, which he was alone in the holding cell. It was about a 6x6 holding cell. And they proceeded to try to restrain him.
They were worried with this sweatshirt that he might be trying to kill himself, they said?
Well, that was their story. There's contradictory evidence on that. There was another person in an adjoining holding cell who said that actually Nick was screaming, hollering, and seemed to be having some kind of an emotional issue or a mental health issue, and that they went in to, quote, make him be quiet. But either way, what unfolded next isn't really in dispute much. Mm-hmm. I think it was a total of 6 officers took turns holding Nick down to the ground, prone, meaning his face down into the floor, while he was already handcuffed and while he was already leg shackled, and that went on for nearly 15 minutes and resulted in his death.
And he was crying out during this 15 minutes.
He was. I mean, he was yelling, "It hurts! It hurts! Stop!" And unfortunately, they did not.
And this went on for 15 minutes.
It did.
Okay, so the court ended up looking at this because you and your firm filed a lawsuit saying that this was unconstitutional. Right.
We filed a lawsuit that said this is excessive force, that holding someone in a prone position until they can no longer breathe, it's unnecessary, that it's unreasonable to do that. And By the way, prone restraint, back in 1995, the Department of Justice issued a bulletin to all law enforcement agencies telling them about the dangers of prone restraint. The Department of Justice commissioned some research because they said, hey, we've got a lot of people dying in custody. What is happening here? So they looked into it, and they found that a lot of these people who were dying fit the factual pattern of Nicholas Gilbert or even George Floyd, where they're being held prone on the ground. And what happens is that as they're being held down, they start to struggle for air. And the natural reaction to oxygen deficiency is, of course, you're going to try to fight more. You're going to try to fight. And that causes the officers to push down again. And it's just a vicious cycle that they get into. So we filed the lawsuit saying that, this has been known that this is dangerous. They should have handled this in a different way. What they did was excessive force. Unfortunately, the district court got rid of the case, granted summary judgment based on qualified immunity. Then we appealed to the Eighth Circuit, and the Eighth Circuit took it a step further and said, what happened was not excessive force. It was not unreasonable because he was continuing to try to get up off the ground. So they said they needed to hold him down still, I guess. And then, obviously, now the Supreme Court They seem to disagree with that.
Yeah, the Supreme Court specifically looked at a few things here. They said that it was relevant that he was in handcuffs and his legs were shackled, and it was relevant that it went on for 15 minutes, that you can maybe use these restraints if someone's resisting. But these were some factors that it seems like his resistance could only be limited under those scenarios. How important was that to what they found here?
Well, I think it's crucial. I mean, the long-standing guidance to law enforcement agencies is that it's okay to have someone in a prone position until you get them handcuffed. Mm-hmm. But once you get them handcuffed, you're supposed to turn them on their side so they can breathe. They're in a rescue position at that point. And so I think that was key to the Supreme Court here because, number one, he's in a holding cell. If they wanted to get the sweatshirt away from him, they could have taken the sweatshirt, left the room with it, and shut the door and locked him back in there. Number two, then they get him handcuffed. Number three, they have him shackled, his legs shackled together, and then there's multiple officers taking turns holding him down to the ground. So the Supreme Court is saying, hey, look at the circumstances. It can't be that it's always constitutional, that it's always reasonable to put asphyxiating pressure on somebody just because they're struggling.
So the oddity of the Supreme Court's ruling here is that they didn't just say, you can't do this. We're going to find in favor of the family of your client, Nicholas Gilbert. They said, we're going to send this back to the Eighth Circuit Court to look at this again. So this goes right back to the court that found against you. Are you worried you could end up with the same outcome, even though the court is saying you got to look carefully at this particular issue?
I think the court will carefully study it, and I do think this time that they will find that under these circumstances that it was excessive force. But you're right. The fight is not over, and it will not be over there. Hopefully the Eighth Circuit changes its mind on this issue. Hopefully it sends it back to the district court here, and hopefully Nicholas's family gets their day in court.
So Justice Alito dissented in this case, and Justice Thomas and Justice Gorsuch signed on to his dissent. And he said that the court was evading the real issue, and that's whether summary judgment was correct, whether if all the facts were favorable to you, if this was allowed, what these officers did. And Alito said the court should either deny review or, quote, have the case briefed and argued, roll up our sleeves, and decide the real issue. He said basically the court dodged this one. Do you think he had a point there?
I don't. I think that it's an interesting dissent. I'm not sure exactly why. I don't think we'll ever know exactly what was going on amongst the justices.
Don't you wish you knew?
We do. We really do. But I don't know what he's hinting at. I know that he wanted to grant the petition, and the Supreme Court has several options. They can issue a summary reversal like they did, or they can actually take the case up, hear oral arguments, study all the facts, and come to a decision. So, we would have been okay with that too. So, not a bad dissent to have if you're on our side.
Yeah, it is interesting. Now, he did note a few things in this case. He said, this is from Judge Alito's dissent, quote, the officers plainly had a reasonable basis for using some degree of force to restrain Gilbert so that he would not harm himself. And it appears that Gilbert, despite his slight stature, put up a fierce and prolonged resistance. What would you say to that interpretation?
I say, of course, they could use some force. But this is a case about what's reasonable and what's unreasonable. And that's what distinguishes this case. If they truly thought that Nicholas needed to be restrained in some way, even though he was already in a holding cell, even though he was already handcuffed, even though he was already on the ground with his legs shackled, then hold him on his side. Follow the well-known guidance that's out there about how to safely restrain someone. So, some force, sure. I think police officers have a very difficult job, and I think the lines are hard to see, and I think it would be great if the courts could draw some clearer lines. I think everybody would approve of that.
Something else Justice Alito mentioned, or actually, this comes out of the Eighth Circuit decision on this. They mentioned that he had meth in his system and that he did have some considerable heart disease. Those are obviously facts that you guys had to consider as you're making the argument here. That doesn't change anything for you as far as these restraints.
No, I mean, his cause of death was asphyxiation. His cause of death was through forcible restraint. It was through not getting enough oxygen into his body. I mean, it's certainly true that Nick had a drug problem. It's certainly true that there was some methamphetamine found in his system, but that doesn't change the result. I mean, if anything, and it's been well known for 2 decades now that people who are possibly under the influence of drugs or alcohol, that it's easier to suffocate or asphyxiate those people.
All the more reason not to hold them down for 15 minutes.
Correct.
So with this ruling, as we mentioned, this is a good ruling for you guys in this case. It sees new life. The Eighth Circuit is going to have to look at this again. And yet, as Judge Alito points out, it's not the final thing in this case. It's still going back. Do you think this ruling is enough to put police departments on notice that they need to be more careful with this kind of restraint?
I think it should. I think it should put both courts reviewing these cases on notice that they need to be particularly careful with this type of restraint. And it should put police officers on notice as well that they need to follow the well-known guidance. Now, I think we need to go further. I think that it would be great to see an opinion from the Eighth Circuit that addresses some of these issues. I think we need more, but I think this is a great first step.
Do you think now that you have this favorable ruling, this is something where the city's going to want to settle and you'd be open to that?
You know, I can't negotiate on air, but here's the thing is I've been shocked that the city has continued to pursue this, very frankly, through multiple administrations. The city has always expressed their outrage about what happened to George Floyd and things like that, but it's shocking to the family at least, and we've talked about it with them a lot, that they're not owning up to what happened in their own backyard. So that's problematic for us.
It is interesting. I think we've seen a lot of statements from leaders in the city of St. Louis who are upset about what happened to George Floyd. And there's some clear echoes here in this case. Does that seem like hypocrisy?
Yes, there's no other way to put it. I mean, everyone agrees, and it's right. They should express outrage about what happened to George Floyd, and other people around the country have had something similar happen. But you have to look in the mirror and take a look at what's going on in your own city. You have to take a look at what your own police officers are doing and make some changes here. Have a policy in place about prone restraint, about compression asphyxia. And that's not something that we have here. We don't have a
So there's no policy on that in the city of St. Louis?
They do not have a policy.
Even today?
It's been several years since I had the chance to sit down with people from the city and ask them questions. Mm-hmm. But at the time we took those depositions, they had no policy in place. There was not one in place at the time. I'm not aware of them putting anything into place. And not only that, there's no official training on the issue, despite this bulletin being issued in 1995.
And this training was a big part of your original lawsuit here, that you were saying all these officers who did this, the city was in charge of these people. And as you keep using this phrase here about how there had been some clear guidance on this. This was not something that they got training in, not to do this or not to do this for so long?
No, we asked the city through the discovery process in the case for any documents they had, any training documents, policy documents, anything that had anything to do with these issues of prone restraint or positional asphyxia or compression asphyxia, and nothing. They had nothing. And then we asked them questions. What is your policy? Where is it? And they don't have a policy. They did not have official training on it. So that is a big part of the case because, it's really hard to blame police officers for what they do when they aren't getting the kind of training and they don't have the kind of clear-cut policies out there that will tell them what they can and can't do.
So we've been talking a lot about policies today, and this is important stuff, and these prone restraints, this is important. But beyond this, there's the life of a young man here. How is Nicholas Gilbert's family doing today?
They're okay. They'll never get over it. They're struggling through it. We talk frequently about it, and they miss him dearly. They really do. And I think Jody, his mom in particular, would just like everybody to know that he was a happy young man, that he had plans, that like a lot of people, he struggled with substance abuse, but he was loved, and they miss him.
Well, Kevin Carnie Jr., attorney with the Simon Law Firm, I want to thank you so much for joining us today.
Thank you for having me.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri, St. Louis.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.